Good morning. My name is Chuck Van Horn. I'm a shareholder at the Atlanta law firm of Berman, Fink, Van Horn. I've been practicing for about 25 years, and my practice focuses primarily on the litigation of real estate disputes, business disputes, and cases involving financial institutions. I'm here today to talk to you about kind of a toolkit of establishing the right things throughout pretrial discovery and honing your pre-civil litigation skills. When are you going to mediate? And there's really no right answer here. There are times in the right circumstances where conducting a mediation before any kind of lawsuit or arbitration claim has been initiated is appropriate for the reasons Jim identified. That is, limited information ahead of time, and the clients may have high emotional investment. It may not just be an appropriate vehicle at that stage, but it can certainly be effective. And that's really kind of an experience factor for the attorney to kind of get involved and assess whether mediation is appropriate before things really start rolling along on the litigation train and expense has been truly committed to the case. If you're going to mediate, you have to decide who your neutral is going to be. And there are a lot of factors that go into that analysis, including the expertise of the mediator, the experience that either you as an attorney or the opposing lawyer, other folks in your firm or your other professional colleagues have had with experience for that particular mediator. And all mediators have variable strengths and weaknesses. What they can bring to the table may be great for a particular type of case, but that personality or their strengths are not as well suited for a different type of dispute. And that's really going to be incumbent upon you to assess what are the roadblocks to a settlement, what are the things you need a mediator to see through, whether it's understanding complex legal issues, dealing with challenges from a client control standpoint, unreasonable expectations, going back to something Jim identified from your first client meeting. And the strengths of any particular mediator may be better suited depending on which variable seems to be the primary dominant factor that you've identified ahead of time. Which then really brings us to preparing for a mediation. I'll be first to admit that I've been guilty of this. When you decide to do a mediation, you tend to dive in and get refamiliarized with all of the substantive facts of the case, why you're right, why the defense or the position taken by the opposing party is flawed, and kind of regurgitating a lot of your legal and factual analysis that you've gathered. But there's a lot more to preparing for mediation than just solely having a great command of the issues in your case. For example, going back under that global heading of managing expectations, who's coming to the mediation? Are you going to insist, if there's insurance involved, that a representative of the carrier be present? And for a variety of reasons, that may be something that's important to the case, and in other instances, it's not a crucial factor, but that's something you need to consider. Who do you want on your side present for the case? If you're dealing with a company, is a company representative appropriate? Is someone from the in-house legal department needed? And again, there's no right or wrong answer. It may depend on the type of case, the issues that are involved, the financial amounts that are in consideration. But think about that ahead of time, because that will also bring us back to this heading of managing expectations, is talking through with the client. Jim highlighted something that I tend to do also in particularly more complex cases, is sketching out bullet points of all of the things that I'm going to want to accomplish in the mediation. And frankly, the number tends to not make that list. It's all of the other variables. Do you want confidentiality? Can you afford to lose this ongoing business relationship, and once this case is resolved, never do business with these folks again? And a host of other issues along the way, so when it comes time to structuring a settlement, you're not the day after remembering a variable that has great business considerations but was never discussed during the mediation. As part of that, You're then going to necessarily have dialogue with your own client about what the client's expectations are during mediation. One that gives you a great roadmap for where things may head. It will give you an idea as to what the true pressure points are. It could be that your client representative is getting great pressure from a certain business unit to make sure that the following objective is reached in mediation. That's something that's not obvious in the litigation papers, but it's a behind-the-scenes variable that you can employ very effectively during the mediation session. It's something that the other side may give you really without giving it a ton of thought. You look like a hero, but you've in the big picture accomplished the ultimate goal, which is getting this dispute behind everybody. In that preparation for mediation, over time, I have tended to never actually quiz my clients on what their ultimate bottom line is, whether that's how much they would be willing to pay or how much they would be willing to take. That's something of I have a hyper-competitive streak in me, so I'm always trying to exceed those. I don't want anyone to perceive that I'm just driving for the middle and ultimately paying what they told me their threshold was. That's a personal quirk of mine. But the other factors Jim identified, I think, are spot on in terms of making sure you have a handle ahead of time as to what you're looking to accomplish out of the mediation. And then that's going to allow you to draft the most effective mediation statement. Your mediation statement should not just be a newly kind of spun version of a motion for summary judgment or some other legal memorandum you've written in the case. Certainly the legal facts, the facts of the case and the legal principles against which those facts are kind of played are of course governing, and most mediators are lawyers and they appreciate that kind of the rules of the road will certainly impact what may happen at a mediation, what may drive a resolution. But there's certainly a lot more to it, and that is where you can use your pre-mediation preparation with your client, with other folks in your office, outlining what you're looking to accomplish, and give the mediator some goals. We need to have this behind us for the following reasons. And it could be a lot of things that are not monetary, particularly in the business context. That's going to give your mediator the best kind of tool or the best pot of information to use throughout the session to try to maximize the chance of a resolution. And that's the goal. You're not trying to win the mediation, and you certainly are not trying to just persuade the mediator that you're right. That's what judges or arbitrators are for. If it is so important to, in quotes, win, then don't go to mediation. And that's a big step for people, and that's why picking the right time to mediate is important. Jim highlighted that there has to be a spirit of cooperation kind of simmering underneath when you're going to engage in a mediation session. And I tell clients a lot, it's not about convincing the other side that you're right or demonstrating to them why they're not right. But it's really about managing control. If you can take their perspective away from winning, losing, because there is a path where they can achieve that, but it's about control. That is, coming up with a resolution that they can use effectively and then turn their attention and resources to other things, but they can manage the ultimate outcome. And that's true on both sides. In that managing expectations, educating the mediator, I also try and remind clients that a mediator's greatest success tool, frankly, is to brag how many cases they can successfully resolve. So the mediator is not motivated to decide that this particular case is worth a certain dollar amount and make sure that someone's not paying more than that or that the claimant's not recovering more than that number. That's not the goal. The goal for the mediator is to decide how far I'll go and decide how far, for instance, Jim's client's willing to go. And as long as they intersect, there's a deal, the mediator's accomplished their goal. And the ultimate objective for the mediator is to reach a resolution, not to decide what's fair. Inside the mediation statement is where you can candidly identify the things that have left you or the other lawyer or the clients themselves without lawyers incapable of reaching a resolution. If it was, in quotes, that simple, they wouldn't need me, and they certainly wouldn't need to pay me to turn around to pay another neutral to resolve their dispute. So there's got to be more going on than just one person's unhappy with the behavior of another person. And that could be a lot of things. It could be pride. It could be having to maintain a business relationship. It could be not, frankly, being willing to tell your supervisors that this contract never got off the ground and you have to salvage this recovery somehow. There could be a lot of things going on, and a lot of them, most of the time, frankly, are not legal. It could be high emotions from one party or another, all of which, if you can identify those issues in your opening statement, in your mediation statement, the mediator is just well educated on kind of what the friction points are. If you know those friction points, that's going to allow you to kind of draw and present the most powerful opening statement that you can. In your opening statement, it's not designed to be the same opening statement you would give at an arbitration or a trial. It's not the appropriate time to try to bludgeon the other side into why their position is so flawed or why you are just so darn right. Try the best you can to connect with the other side. That doesn't mean you have to agree with them, but demonstrate that you have given thought to what their issue is, what's motivating their issue, and that you are committed to doing everything you can to try to address that issue in a circumstance that is respectful of your client's view. And that's not an unfair rule for either side to be kind of operating on in a mediation. A lot of times what drives these cases, personal injury in particular is one where this is common, is someone feeling like they have never been taken seriously. They have been marginalized. I got hit in this accident and no one ever really stopped to find out, what happened or how I'm doing. And there's a lot of reasons for that. If you're on the defense side, you're immediately not going to want your driver or whoever it is to be communicating with the injured person for obvious reasons. But you can see where that starts breeding then this kind of distrust or no one cares about me kind of perspective. And at mediation, it's a great path to try and overcome that and use that as the jumping off point for dialogue. I would strongly encourage you not to use the opening statement as a time to hammer on, again, the flaws of one person's case and the strength of your case. I would save a lot of that, frankly, for some of the private caucus, which is kind of the name or terminology given for the meetings that occur after the opening statements. You can professionally assess that you think it's just a terrible idea and that will make everyone's job, especially the mediators, a greater challenge. It's already a challenge if I can't work with another lawyer and come up with a swift or kind of a well thought out resolution. You don't need to already be kind of fighting uphill just because everyone's sitting across the table staring at each other and spitting nails. In that scenario, I would encourage you to try to really think that through. Again, that's back to the preparation session. No matter how good your mediation statement is, I strongly encourage you to have phone dialogue with the mediator before the session. There are things that sometimes are easier to convey just by the spoken word than by the written word. And it also affords the mediators an opportunity to ask some questions back. They're going to have initial impressions from having read your statement, and those initial impressions are hugely valuable. Whether the mediator maybe misunderstood an issue and you can clarify something quickly and avoid distraction and, again, get us back focused on reaching a resolution. It could be they picked up on a nuance that either you hadn't prioritize as much as the mediator had. And don't forget, the mediator's probably seen a statement from the other side, so their questions may be colored or their analysis may be tainted by having seen someone else's identification of the roadblocks. So let the mediator do their job. Try and talk to the mediator ahead of time and get a head start, and that's when you need to have the discussion about whether skipping opening statements is effective for that particular session. So we've gone through the opening statement. If we have one, you've certainly gone through the mediation statement. Now you're really kind of turning over a lot of the shuffling or the hard work, frankly, to the mediator. So let's talk about then kind of the next stage, because the opening statement session will, if it occurs, will certainly only take up the very first half hour, maybe hour of a mediation for what could turn out to be a pretty long day. The process, and that's the phrase I've heard just so many people use over and over again, that mediation is a process. For all of the reasons that the opposing party's initial demand or their initial offer is just spectacularly outrageous to you, we should pack up and just get out of here. I can get back to work by lunch, says the client, and get back to doing what I need to be doing every day. The precise discussion is happening in the other room with respect to your offer or your demand. Understand it's a process. Educate your client ahead of time that something about the human psyche requires there to be, almost like making good chili, a simmering of an all-day affair before you're really there, before you might have a finished product. This is not something you can microwave. And going back to criticize, let's say me, for example, if it was so simple, I would have settled this case already. I would have set a number, Jim would have thrown out a number, and after a couple more back and forths, within an hour, the case would be over. We couldn't do that, therefore we came to somebody to help us bridge those gaps. And working through those gaps takes time. So use your mediator. I was identifying the idea of holding some of your real substantive issues, whether they're legal or whether it is, I don't think the other side can prove their part of the case, or I don't think they have the witnesses they believe they have, or Jim identified even analyzing a case up front. Can they pay? Do they have the patience to see a case through several years of litigation? Are there other motivators that we're aware of that may drive a settlement? For example, we are hearing that this business might be up for sale. They can't have an open piece of litigation and try and be sold, particularly if it's of any significance. Knowing all of those things, give them to your mediator and tell them, ask him or her to try to help you analyze that issue. And I would strongly encourage you to position it or remind your mediator of the value of positioning some of those issues not in a confrontational context, rather in an information gathering. Lawyer I worked with many years ago always described mediation. One of the hidden benefits is to just sit and act like a sponge. That is, you're going to learn a lot about a case and facts and issues just by listening, not always talking. But ask the mediator, can you find out from them, how do they intend to overcome this item? Which is a much more open-ended way of gathering information than to tell them, I have them dead to rights on this issue, they're crazy. That's not taking an open mind on your side, and you're also educating the mediator that you've given some thought to the true nuances of the case and allowing the mediator to go ask that question. You've just gotten an answer that might be $5,000 worth of discovery you just saved because he walks back in or she walks back in and says, they have a document that's going to answer that question, to which you say, can I see it? And you've learned a lot of information, but you've also started really clicking off your list of roadblocks that have prevented you from settling the case without mediation. Maybe you never appreciated that issue, or you may be able to assess that their answer to your question is pretty flimsy, which is a signal that they are either ill-prepared to deal with that. Let's say it's a particular defense. The they're ill prepared or they will never be able to overcome that defense, and then you can factor that into your negotiation. Using a situation or that path I just described, you can see how much more effective it could be for you, short of just sitting in the opening statement and just essentially screaming at the other side why you're going to win on this particular issue. That's very inconsistent with the overall theme of, hey, let's sit down and see if we can figure this out, yet you've accomplished a similar goal. You've been able to analyze a factor in the case and assemble it into your overall pitch on whether the case is going to settle, what's an appropriate platform for it to settle on, and God forbid it doesn't settle, at least you've gotten a lot of answers about things kind of going forward. In that joint negotiation phase of mediation, I can't emphasize enough patience. The private caucuses with the mediator, as identified here in the outline, are where you're really going to spend a lot of time, really working through particular issues, working through a lot of financial considerations, and really mapping out where the end game may be. During that session, I would encourage you to ask the mediator a lot of questions. What are you hearing in the other room? Who's driving the conversation in the other room? Is it the lawyer? Is it the client? Those sorts of things, because that's going to help you analyze, even with your own client, what your next move may be, and then 2 or 3 moves after that. And use the mediator's kind of eyes and ears going back and forth into the room to help gauge how you maximize the information that you can gather out of these private caucuses with the mediator. There are times when you may want to talk to the mediator without any parties being present. For example, if your client is particularly hung up on a certain issue, and that's very valid, and it may be a business consideration that they just can't move off of, but if you can say that to the mediator or ask the mediator certain questions outside your client's presence, sometimes that can be hugely effective, especially if it looks like the mediation is heading toward a predictable impasse, potentially much earlier than you had otherwise anticipated. Maybe the mediator will suggest a joint negotiation just with the lawyers. I have a certain control freak in addition to being hyper competitive. So I'm always a little anxious when mediators request to meet with my clients without me. That's, again, a very case-by-case analysis as to whether I think that's a good idea. But if that were to happen, you can gain additional confidence in the outcome of that if you've done a lot of pre-mediation preparation with your client, walking through kind of how everything's going to work, and that they have a very good handle on what they're truly looking to get out of this exercise. But I really cannot emphasize enough just the role that mediation can play. Where I tend to practice, mostly in the Southeast, there's been a huge swing over the years to what we call evaluative mediation. When Jim and I first started practicing a few decades ago, mediation was kind of in its infancy and has really matured over the past couple decades. And for a window there, I became kind of frustrated with mediation, I have to say, because I found too many times I felt like it was shuttle diplomacy, where I would make an offer, it would be literally walked into the other room, and then a time later, an offer would just come back. And you kind of felt like the mediator was literally just a courier and not rolling up their proverbial sleeves, really working things through. We have seen more evaluative mediation where the mediator will look at you and say, I don't think that issue is going to carry the day for you, or I think they got you on this, or vice versa. And they'll tell you, I have been telling the other side all day that if that's the best they have on that, it's not going to be enough. And I hugely appreciate that. I think it makes everyone's ability to really kind of separate the pomp and circumstance or the puffing from the true reality, which is to always be comparing a mediation resolution to what would happen if you were to continue to pay me to take your case all the way through the end. You have to know what the potential outcome is, and an evaluative mediation can sometimes be that dose of reality that one side or the other needs, again, to get over one of those big roadblocks and getting yourself to a resolution. I want to kind of talk a little bit about arbitration, but before I swing to that, I wanted to highlight something I talked about at the very beginning of mediation, and even Jim highlighted as one of the huge advantages, and it cannot be emphasized enough, which is control. The ability to control a resolution is, for me at least, the greatest driver to mediation, to doing mediation, and to why I think it's so successful. There's no question that litigation is exceptionally expensive. It's a huge drain on resources. That is someone's time, energy, kind of that gray hair factor that comes with it. And there's gargantuan unpredictability. You cannot tell a client with a straight face what will happen at trial for a variety of reasons, which is picking a jury of your peers is probably one of the greatest misnomers in the legal profession. The round of 12 you will get at a jury is very difficult to identify well ahead of time as to how they will analyze any issue. Jury selection is a very valuable tool, and this is not a trial seminar at all, but kind of tongue-in-cheek. A number of times I've reminded clients that the 12 people you will get on your jury, just consider the last time you were in a grocery store and you were in line, and the 5 or 6 people in front of you and the 5 or 6 people behind you. So that includes the people who are reading all the tabloids, the person who put an entire cart full of groceries in the 10 and under thing because they just can't read or don't pay attention, don't care. Those are likely the people that are going to decide potentially your multi-million-dollar case. It could be the end or the beginning of your company. It could be the resolution to a catastrophic injury or anything else. That is a potentially scary proposition. Despite years of experience trying a lot of cases, Jim and I, we don't get the pleasure of sitting on the jury deciding the outcome. In a mediation, you have massive control of the outcome. And that alone, like I said, is kind of the driving factor for me as to why I'm such a huge fan of mediation. What are you going to do if you are successful? If you are fortunate enough to have closed out your case, what are you going to do with it? Going all the way back to Jim's identifying kind of checklist at the beginning as to having, like, documenting your settlements in detail. If you can come up with a bullet point or some kind of outline before you walk into a mediation, then you're hugely downfield in terms of having a well-structured kind of mediation settlement. What you don't want to be doing is the next morning your client saying, oh yeah, we need to make sure they'll do confidentiality. At least in Georgia, for example, confidentiality, there's cases that say that a confidentiality provision is considered a material term. So if not expressly negotiated, you can't insist on it later. Now the other side may give it to you, but you can't insist on it, I guess is the point. And there are other variables like that. Most often, particularly with lawyers that I've dealt with before or mediators that I've dealt with before, we will write up a settlement memorandum at the end of mediation that may be, especially using the outline that you had prepared in the weeks leading up to mediation as kind of your starting point, and it could have 5, 10, 15, 20 bullets on it. But it will not be a lengthy single-spaced document like you would see in a full-blown settlement agreement. But at least I've always felt more comfortable walking out of a mediation with something that's signed by everybody. So God forbid that the settlement agreement drafting falls apart later, you can always fall back on your settlement memorandum and you still have a binding agreement that could be enforced if you ever had to go to a court or an arbitrator to enforce it. Which brings us to arbitration.
So Chuck, before you go there, just a couple points on some things you said. You talked about evaluative mediation versus not. I think you got to look at your client and say, I've had literally mediations where they're shuttling back and forth and it's like an auction. And I have clients who get very turned off by that and say, aren't we going to discuss these numbers? You want to make sure your client, if it's going to be like an auction, which sometimes is good and sometimes is bad, you've got to make sure your client's going to be prepared for that, because I have a lot of clients who are going to look and say, I'm not here to just throw out numbers. I want to have a basis and a reason for those numbers, and so we're not going to do this by auction. And that goes back to what their expectations are. How sophisticated are they in mediation? I always preach patience to them. Look, it's 10 o'clock. Let's take another look at this at 2 o'clock, because we're in this feel you out stage, chest thumping stage, and they want $10 million, and we've offered $2,500. And understand, you can't lose faith with it right now. Just bear with it. Be patient. Let's see how the day goes. You want to make sure that they don't have any other obligations, so they're looking at their watch, that they're wanting to catch a flight, any of those kind of things. And then, of course, you want to make sure you have the right people there that actually have the settlement authority and have the right characteristics to be your good client at a mediation, versus the people that are going to lose patience with the process, going to have to call somebody else to get authority, those sorts of things.
When Jim was identifying in the first session today, taking on a new client, taking on a new matter, and then making a decision whether you pursue litigation, do you send a demand letter first, one of the alternatives he identified was going to arbitration. And for those of you who don't have a lot of experience with it, arbitration is essentially a contractually created forum to resolve cases. So think of it as a private court system. As a private court system, like Jim identified, you have to pay for the court system. So whoever the decision maker or makers, because some arbitrations are done by a panel, some are done by only one decision maker or arbiter, that person or persons need to be compensated for the time they dedicate to reading all the materials that are submitted in the case, pondering the legal issues that come up, resolving potential disputes that crop up during the dispute, like discovery matters or other things, and governing and overseeing the actual trial or arbitration of the case itself. Arbitration is exceptionally common, particularly in the construction industry. There are certain types of employment cases that tend to be arbitrated. And then you see more and more arbitration clauses being introduced into business or contractual relationships, particularly between a company and one of its vendors, whether it's a supply contract or a software license contract or something else, where the parties have decided that if a dispute arises, the parties are compelled to have it decided outside the traditional court system. Typically, the motivation for that is, as Jim identified it in his initial checklist, the idea that things are private, so people can't kind of be snooping around. If you're some large company, you don't want people kind of knowing your business. And there's a certain expectation that arbitrations tend to move more quickly than normal court cases. In my experience, that is not always true. I've had arbitrations that tended to just slog along just like characteristics that people make fun of traditional litigation for. And there's also some thought that arbitrations can be less expensive, which in the right context can certainly be true, particularly because discovery normally is substantially more limited. The parties may agree or the arbitrator may decree that there will not be summary judgment motions filed. A lot of the big events in traditional litigation that are quite expensive can take up a lot of time. So not only in addition to the time to prepare and the expense of, for instance, a summary judgment motion, but think about the amount of time that a judge needs to adequately review and decide a motion for summary judgment. If that entire episode is avoided, then we can kind of get to the end result that much faster. Arbitrations are taking different forms. The American Arbitration Association, commonly known as the AAA, has been kind of a bellwether organization for these issues for quite a long time. And a number of other shops have cropped up over the past couple decades that also offer arbitration services. Now, in addition to paying the arbitrator, him or herself, you're also going to pay a fee to the administrative staff to oversee the case. But in the right circumstance, it can really be a huge advantage in terms of moving your case along. And if I haven't bored you yet with Jim's phrase of managing expectations, here's another example. Let your client understand what arbitration is all about. There are certainly advantages to it. Where things can move faster. You can kind of cut to the quick, if you will, in the right circumstance. But one of the big issues with arbitration is the lack of appealability or the lack of redress. If something goes off the rails, if there's a ruling that really just seems kind of out of left field, or if the arbitrator just didn't pick up on an issue and you get that final award, and it's very clear that for whatever reason, despite your efforts or the efforts of the opposing side, the arbitrator just misunderstood and just got something plain wrong, you're kind of stuck. In most jurisdictions, the ability to attack an arbitration is spectacularly limited. That may be okay in the right circumstance, but in another circumstance, you can see where that's just a terrible idea. Now, I will balance that lack of appealability with another motivation for some businesses in particular to enjoy arbitration is you get finality, you get to kind of move on, but you've also avoided the consequence of a really bad or adverse ruling. And where that comes into play is case number 2, case number 3, case number 4. You've not created bad law where one of your vendors has kind of gotten or achieved a result, and all of a sudden your business client, in particular, I see this in business cases, is thinking, oh crud, right? Here we go, now everybody and their brother is going to be lining up making claims that are comparable. The discovery world in arbitration is probably the area where I have gained disfavor for arbitration in certain contexts because we are creatures of habit. We like control. And I always feel motivated to get some amount of discovery during arbitration so that I really have a good handle on what my case is about. A business case worth a lot of money, has huge impact on the business. It almost seems unfair to try to have someone decide that result with finality and have very limited facts to really support your position or to kind of poke holes in the opposing party's position. A lot of that may be governed in the agreement, the contract that spells out the obligation of the parties to go to arbitration, but in the event that those things are not spelled out, really give some thought ahead of time to what kind of discovery. And there are ways to kind of split that proverbial baby. That is, maybe limit it to a certain number of depositions per side, a certain number of requests for production of documents ahead of time. To use arbitration for the reason it was invented in the first place, you'll see one of the boxes here on this slide is organization, organization, organization. And that is really think your case through as to what you need to prove or disprove the issues in the case and focus solely on that. This is not wild goose chase, scorched earth approaches are not really, they don't work real well in an arbitration context because it's all about kind of getting the most bang for your buck, and that can include just time. And then with respect to arbitration, also consider the last box there. Be open to creative proposals. There may be ways to structure an arbitration that you cannot accomplish in traditional litigation. For example, do you bifurcate your case and just have the arbitrator decide one threshold issue and that's all? Then if you win or lose that issue, that could have massive domino effects on other parts of the dispute and you've saved all the time and money fighting over that if the initial issue did or didn't go your way. And think about those things, because you can't do those in regular court. You can't just say to a judge, how about we have a trial for 4 hours and then tell us what you think on this one issue, and then we'll come back in a week and we'll do a little more. It doesn't work that way. So think about that. In the complex business cases, it could be a great opportunity to try to stage certain pieces of your case in a way that truly gets you to a resolution. And there's really no end to the creativity. The arbitrator, by virtue of being paid by you and the other party in the case, is really essentially working for you. And they should be open to these ideas, because the whole motivation is to come up with paths that are alternative to traditional litigation, putting 12 people in a jury box and having a traditional trial you're used to seeing on TV. So be open to those ideas. Think about when arbitration may be a good alternative, and try to structure your arbitration in a way that delivers the advantages for which arbitration was originally invented. In both contexts, mediation and arbitration, I think one of the great takeaways is the idea that you can fashion things in a way that you can't accomplish in traditional litigation. In the mediation forum, for example, you can get things that no jury can give you: money over time, an apology letter, confidentiality, certain other structures of things. I will come back and finish the wall at this site, or certain things like that that no jury can give. The only thing a jury can give you is a dollar figure. And a lot of times that's not enough to resolve a case. And similarly in arbitration, with a lot of effort ahead of time and some really deep thought, you may be able to structure the dispute resolution process in a way that most efficiently gets your client and the opposing party, frankly, kind of back to business, or back to doing the things they were doing before they needed you or someone like Jim to help them. We're going to take a swift break, and then we'll be back, and Jim will kind of cover some issues associated with the laws on damages.
We're back from our break, and we're now going to turn to the law of damages. And again, we're talking about pretrial things, and we're talking about things that don't involve direct interactions at trial. And it's funny, when you think about damages, obviously money or the recovery of money is at the heart of every civil case, or just about every civil case. I mean, there's injunctive relief, there's other forms of relief that are non-monetary, but the lion's share of cases deal with damages and monetary relief. Yet, as civil litigators, I think a lot of times people take damages for granted, and they don't spend the time on the front end of the case, whether it's the defense side or the plaintiff side, working up the damages case, both from a factual perspective and from a legal and evidentiary perspective, in a proper way. In other words, sometimes it's sort of a foregone conclusion that you're going to get there later. And everyone's seen the interrogatory that comes in and says, quantify your damages, and then you list and say, well, we haven't done so yet, we're going to figure it out, and we'll let you know when we figure it out, something to that effect. And of course, that should be something that triggers in your head, well, why haven't we figured out what our damages are? Is it because we don't know? It's because our client hasn't figured it out? Do I need to ask better questions of our client? Do I need to involve an expert? Do I need to do some research and determine what's available or what's not available? Or if there's some quirky rule in this particular district or this particular state as to what can and can't be accomplished in this type of case? So I think, it doesn't seem like it'd be the case that damages get overlooked, but my experience is sometimes damages get overlooked because you're, a party's so wanting to get a case moving, and they say, we'll figure it out later on. And so what I'm going to talk about here for the next section is to talk about the types of damages and how those can be worked up ahead of time to command the case. Or if you're on the defense side, making sure you understand what the defenses to the damages are going to be, what particular things can and can't be requested. So here's the topics I'm going to cover. Types of damages in civil suits. Again, we're talking about civil. We're not talking about anything that would extend outside of that. And again, this would apply, as Chuck mentioned, in an arbitration proceeding as well as typical court proceeding. Quantifying damages, and that's what I was just talking about a little bit. Documenting the extent of the injury and the damage. liens and subrogation, and I touched on this a little bit already, understanding how everything fits together and filters down is going to be critically important. Calculating non-economic damages, and again, we could spend a whole day talking about non-economic damages. We could spend a whole day talking about things that are recoverable versus not recoverable. And then that wild card of pain and suffering that you're going to see in a personal injury case. And I will never forget the first personal injury case that I took to trial as a defense attorney, where the other side asked for that 7-figure amount for pain and suffering to a jury, and your knees get a little weak and you think to yourself, gosh, if this goes through, this is going to be a big problem for me career-wise. And so that's a wild card. Now, you're probably not going to see that in a business case, in a contract case, but it's something I'm going to talk about here today. And again, I'm going to talk about this, but I think the overlay to all this is what I mentioned, which is getting a handle on this well before trial. Getting a handle on this either on the front end as you meet the client, or getting a handle on it as you start the case, and not trying to do it last minute where you're preparing your exhibits for trial and they keep changing. I had an arbitration a couple years ago where the other side filed their arbitration case, and I think they asked for $5 million. And then they asked for 10. And then they asked for 15. And then they asked for 20. When we got to arbitration, they asked for $25 million. Now, that was such a fantasy number anyway, it didn't matter. But I was able to in arbitration, and I probably wouldn't have been able to do this in a court proceeding. As Chuck mentioned, the rules of discovery, the rules of evidence are relaxed, but I was able to point out to the arbitrator through cross-examination that their numbers kept changing. And the reason their numbers kept changing is because of what I just said, which is they never sat down and figured out their damages in any sort of real and practical way, essentially till arbitration. In fact, they were still trying to figure out their damages at arbitration. Their exhibits kept changing, their lines of attack kept changing, which was all good for me because it made it look so mystical in terms of what they were trying to do, which put into the arbitrator's head that these guys are just making this up as they go. That's not the position you want to be. And again, that didn't have anything substantively to do with their case, but I used that as a wedge against them at arbitration when they couldn't get their act together relative to damages. So let's go to that first topic, types of damages in civil suit. And I'm going to talk about each of these, and some are easier than others in terms of getting your mind around. There's direct, there's consequential, and there's incidental. And those are things you learn about in law school, but I'm going to refresh those a little bit today because those are things that I think every case that comes in, you need to filter those through. And again, this isn't just a plaintiff's case, this would be a defense case as well, as what kinds of damages are going to be available? Are there damages that can be overlapped? Can they be pled in the alternative? Is there ones that have to be proven in certain ways through certain means? Do I have to have an expert to do that? I'm going to talk for a few minutes about punitive damages. I mean, punitive damages are great. Punitive damages are pretty rare. Punitive damages, though, can be a nice, if you have the type of case that presents for them, they can be a nice wedge to settle cases. Sometimes they're not insurable. Well, most of the time they're not insurable. It's something that can be used to as a real hammer, whether it's real or not that you're actually going to recover them. And I haven't had very many cases where they've been recovered either against my client. I've never had a case where they've been recovered against my client. I've had cases they've been pled, and I have cases where I've pled them, but they're something that's talked about in the larger non-legal community as something that's out of control. And of course, as lawyers know, we know that they're few and far between in terms of those kinds of cases. Also throw in their costs and fees. Is there going to be a fee shift? Is there going to be Rule 68 type offers? Is there going to be things that are awardable through court procedures relative to costs and fees? And then that other thing I just mentioned, the non-economic damages, the pain and suffering damages. And again, you have one column which is more verifiable, more quantifiable, and then you have the other column which can be a little more variable, and frankly, if you're the defense attorney, a little more worrisome relative to some of the things that you can control on the column with the direct and the consequential and the incidental. So let's drill through these types of damages. Okay, so we remember from contracts class or torts class, direct damages. Those are ones that flow from the breach. They're commonly referred to as general or direct damages. So those are pretty straightforward. But again, you want to know what are the, in this particular jurisdiction, what is considered a direct damage? And how do I have to prove that? Do I have to do that through estimates or repair, or estimates or invoices? Do I have to do that through, is it best practice to use an expert to do that? How am I going to do that? And so direct damages are pretty easy. On the other hand, you want to make sure you know how I have to establish them and what are those that commonly flow from the breach. Okay, so now we talked about direct, let's talk about consequential. So, stem from a seller's repudiation of a contract for the sale of goods. But such damages are only allowed to the extent that they cannot reasonably be prevented by cover or otherwise. We all remember those concepts from law school and from the bar exam. Must be foreseeable. Again, you're examining your case, and again, that's whether you're a plaintiff or a defendant, and you have to say to yourself, are these going to be foreseeable damages? And I have clients that all the time come in and say, we should be able to recover this, and I want all my lost time, and I want all the time I spent on this, I want some sort of lodestar applied to my time, and I want to be able to quantify that. And you have to look at them and say, there's consequential damages that we can recover, and there's consequential damages we can't. And again, it's not only foreseeability, but there's also other things that would go into it. Cover or otherwise. We're speaking of mitigation. These are things that could have been done to prevent additional damage. And again, you want to make sure that when a case comes in, or a case comes in as a defense case, that you're examining these issues to make sure you know how that's going to work and how it may work in a particular jurisdiction or may not work in a particular jurisdiction. Because jurisdiction to jurisdiction, these are overlapping concepts, but they don't always work the same case to case, state to state, jurisdiction to jurisdiction. Again, consequential damages, lost profits. Lost profits, again, you have those in business cases, but what is a lost profit? And again, a lot of times that's going to be something you're going to need an expert to put together. I mean, they flow directly from the breach of contract, so that sounds like a direct damage, and maybe they should be characterized as that, but you're talking about lost profits, you're talking about something that's harder to quantify because you're talking about something that did not occur as opposed to something that did occur. If my house gives way because the contractor didn't do a good job with my foundation, and I have costs that I have to, or repair costs that I have to spend, I can say those are direct costs. What about the consequential damages? Well, I had to stay in a hotel. I missed all these days from work. I had, I missed the promotion at work because I didn't work enough, or I lost my job because I didn't work enough because I was spending too much time with my house falling over. Now we're starting to bleed between direct, foreseeable, consequential. How far out can you go? And I won't go back to law school and all the foreseeability analyses that you can go through, but understand that's where we're talking about in terms of lost profits, in terms of that line of analysis. Recoupment, and again, that's a element or a piece of consequential damages. And then, of course, something that I mentioned before, the economic loss doctrine. That's the overlap, or is this a tort case? Is it a contract case? Where is the overlap, if there is any, between those concepts? And I'll tell you, when I learned that concept in law school, when I learned that concept early in my practice, I thought I had a pretty good handle on it. And it can change, and I know in Minnesota it has changed over the years, and you have cases that factually demonstrate the economic loss doctrine in a great way, and you think you got a handle on it. If you have an economic loss doctrine case, you want to make sure you have briefed that issue to yourself in a research sort of way so you understand it, because again, that's not something you're going to want to do on the fly later, because if a case presents for that, it's something that you're going to want to make sure you're fully aware of and you're fully understanding of what's possible and what's not possible when you're dealing with overlapping tort and contract recoveries. And again, you want to identify that on the front end. And again, as a defendant, you want to identify on the front end. If they put together a complaint in tort, when we got a contract, should you be pleading certain defenses and saying, or even a motion to dismiss or a motion for judgment on the pleadings to say, we should knock this out. We don't want to do 6 months of discovery on this because this is not something that's available. We have a contract. They can't recover in tort, Your Honor. They can't recover those broad damages. And again, that's something you want to think about on the front end. And maybe it's something you can knock out as a defense attorney, so you're not having to deal with that going forward.
If I can jump in for one moment, from a planning standpoint, the lost profit section or component of a business dispute is something unquestionably, like Jim alluded to, clients will come in and identify the parade of horribles that happened because this contractual relationship went sour. Lost profits is going to be one of the first things they're going to emphasize. My whole division couldn't meet these types of goals, and really put some thought into the pursuit of that kind of claim. By no means am I dissuading you from pursuing it, because if you have a good lost profits claim, it's amazing. That's where you're really going to be able to potentially deliver for your client a result that they'll be super satisfied with. But it is not a claim to be taken lightly. Some of the contractual breach damages Jim was referring to are pretty cut and dry. They just kind of flow fairly straightforwardly. Lost profits is going to be a discovery tar baby. And on the defense side, the same thing. There are a lot of areas that make lost profit claims that are not well thought out, easy fodder for really kind of poking some holes in them. So it's just something, if you're going to go down that path, just think about it ahead of time. It can be an essentially effective tool on the claimant's side, but if you don't have it, then you're in for a long slog of discovery with really not a lot of great outcome coming out on the other side.
That's a great point, Chuck. I had an arbitration where my client had terminated a dealer agreement, and the other side, they had direct damages. They had good damages that they could establish, assuming they could establish that we didn't have a basis to terminate the contract in the first place. Yet they spent a lot of energy and a lot of time putting together this lost profits analysis, which was very fanciful. When we got to arbitration, they had an expert come in who was not a very good expert, who hadn't done a lot of testifying, and we contrasted that by not having an expert, an accountant or a financial person, but yet I had consulted with one on honing my cross-examination of their expert. And their entire case, to your point, was tainted by the fact that they had gone so hard on this lost profits thing, and it went so spectacularly bad for them that it sort of infected the rest of their case, that if they had done a more meager or modest claim for lost profits and amped up some of the other parts of their case, they may have been successful. By the time they got done with that piece, though, they didn't look credible anymore. And it was just a bad deal. Good deal for my client, bad deal for them, but they had so overstepped the boundaries of really what was a proper lost profits claim that it really didn't help them relative to the rest of their case. And I think that was the point you're making, is you got to be careful with that. It can be great, or if you go too far, it can be something that the other side's going to hold you up. And I like the term, the tar baby term. So incidental damages, that's the third category: direct, consequential, now incidental. They're recoverable and may include expenses reasonably incurred with affecting cover, any other reasonable expense related to the delay or other breach. And again, so we've got direct, consequential, and incidental. Now let's talk about punitives. Now again, as a civil practitioner, I've certainly had cases where punitive damages come up, and you see the statement from the U.S. Supreme Court on this. But I think in the general press, people, there's a punitive damages case, it gets discussed, and everybody thinks that cases are out of control. I think as day-to-day litigators, we know that's not the case. Now, I did have a case last year where I was able to plead punitive damages. In Minnesota, for instance, you can't plead punitive damages in your initial complaint. You have to move to amend. You have to establish the basis and the right to seek punitive damages through motion practice before you can do so. And that's a pleading limitation that, for instance, in Minnesota, that's been placed on litigants so that people don't put it in their initial complaint. They don't try to drum up a case. They don't try to push around the other side. I haven't had a lot of experience in other states, but my practice pointer on that would be make sure, depending on what state you're in, depending on what jurisdiction is, you understand both from a defense and a plaintiff's perspective how punitive damages can be pled. Can they be pled in an initial complaint? What is the workup that's going to be required? What's going to be necessary to establish them? What is the standard? The standard in Minnesota, for instance, changed and has changed over time. And you know, what kind of case do I have? I mean, business cases are tough for punitive damages. You got to have really good stuff. Personal injury cases are tough for punitive damages. You got to have really good stuff. But you know, when you have that right case that comes in, punitive damages can be great in terms of a hammer. And what I mean by that is if I'm the defense attorney trying to size up a case and I can figure out what my direct damages are, or even my consequential damages, or even the incidentals, and I can figure out attorney's fees, or I can provide estimates for fees and costs. Punitive damages is a whole nother animal, and I need to, it has that exclamation mark after it that people have to pay attention to, businesses have to pay attention to. And again, there's a lot into that in terms of how that gets worked up. How does it get presented to the court? Is that something that's bifurcated and determined afterwards? You know, if you're in arbitration, as Chuck talked about, is this something that can be put to the arbitrator? I would not leave, I just had a case that I settled where the other side was seeking punitive damages in arbitration, and you don't want to leave to chance what the procedure is going to be. Now, you may be under a certain state's law, but now you're in a little bit of no man's land relative to procedure. You know, in Minnesota, for instance, it's a procedural rule that you present punitive damages in a certain way. It's not a substantive rule. So if I'm in arbitration under Minnesota law, do I have to plead it that way? Now, I argued in that case that the arbitrator should act as a gatekeeper to determine if punitive damages should be even pled, and that we should be spending time on this. And the arbitrator in that case we each submitted briefs on the issue of the appropriateness of punitive damages in terms of how it could be established. But again, why am I talking about all this? Why is this so important? Because of course punitive damages fall into that great unknown. I mean, it's like pain and suffering. They can get away from you. There's something you have to worry about. Now, if you complete them in an initial complaint, if you got those kind of facts, they're great in terms of, it presents for a case that may be worth more than it otherwise is because it has that potential. And that's the case I had last year where we amended, the judge granted the motion for punitive damages, boom, we go to mediation, and we got more money than we should have in a typical case because of punitive damages. And I knew what was going on in the other room, which was a negotiation between the insured client and their insurance company who wasn't going to cover punitive damages. At the end of the day, that case settled and I got two different checks because the client paid part of it and the insurance company paid part of it, but there was a negotiation back and forth. And again, you can think about this and take it another step. If you're, and again, this isn't a primer on insurance, but if I'm that insurance company and I have an opportunity to settle a case for an insured that would include punitive damages or the risk or exposure to punitive damages, and I don't do so, and I leave them open to it even though it's not insured, and then they get hit for it, am I exposing myself to a bad faith claim? Now again, that's a lot of concepts to throw out there, but it's just something to think about. And again, that can provide for considerable leverage if you're the plaintiff or a considerable deterrent if you're the defendant. And again, I'm talking about this, it's a rare case that has the ability to have punitive damages, but it's something everyone should have their understanding of both the substance and the procedure or what's necessary, because it can be a good tool to apply in the right case. I talked about this before, costs and fees. Attorney's fees are permitted if authorized by contract or statute. That's pretty much the rule just about anywhere in the United States. You need a contract or you need a statute. to get attorney's fees, unless there's something procedural like a Rule 11 piece. But again, that's going to be more of a sanction on a party versus something that's allowable back and forth. Now, when you see a contract that allows for attorney's fees, or there's a prevailing party provision, that's one thing. What if it's one-sided? I would always check the research to see if there's a reciprocal right that courts have implied in a particular state that says, hey, if one side gets attorney's fees, even though that's what the contract says, the other side does. And in certain circumstances, in cases I've worked on, there is a reciprocal right that may be even statutorily overlaid to particular contracts, and you're going to want to know that. And again, you're going to want to read your attorney's fees provision very carefully, because they come in all shapes and sizes. Some are really well written, some are not. Some talk about reasonable attorney's fees. Some talk about when the attorney's fees meter is going to start. There's you want to make sure what am I dealing with in terms of my attorney's fees provision in my contract. If it's a statutory attorney fees, again, you want to look at how do I need to plead a case to get there in the first place. You don't want to be leaving that to chance. As I talked about, damages can sometimes be an oversight, and you want to make sure you plead your case properly to get there in the first place if they're available. All right, so we've talked about types of damages. Now I want to spend some time talking about quantifying damages. So I've given the chart here of things. So quantifying damages, you got to be definite, it's got to be reliable. So you have that contract, you have repair and replacement, you have lost value, you have invoices, and again, all those things, you need to determine, how am I going to present those? How is the foundation going to be there? Who am I going to need to do these sorts of things? And again, instead of leaving damages to chance later, I want to work through who am I going to need, how am I going to need them to go through direct parts of the proof relative to damages. And then we turn to experts. Am I going to need an expert to talk through royalties? Am I going to need an expert to talk about economic issues? Am I going to need a medical expert who's not only going to quantify the substance of an injury, but also can talk to the amount of care that may be needed later in life? And then there's timing issues, unknown injury, present value of future damages. And again, that goes into that category I was talking about before of pain and suffering. And what's going to, there's a line between what are the unknown injuries, what are the things that are going to occur in the future, what are the future damages that I may need to ask for, and then the pain and suffering that is less quantifiable. I mean, it's something that has to be quantified, but of course it's less quantifiable. And in a plaintiff's personal injury case, typically that's something that's a feel thing too, even a feel thing at trial as to where's the jury going, how much should I ask for, do I ask for too much and spoil the case because I look like I'm greedy. There's a lot of things that go into it. So let's spend a minute talking about quantifying damages. You got to gather evidence. You got to gather the documents both before and after the incident. You're going to gather things as close to the incident as possible. And again, these are general things that you're going to do in every case. Do I need to get an expert opinion put together right away? Do I need to preserve things in a medical case or a personal injury case? Photographs, x-rays, CT scans. Am I going to, if I'm going to need victim testimony to establish things, how am I going to put that through? We talk about the eggshell doctrine. I had a personal injury case recently that I worked up where we were defending a case that was literally a slip and fall in a parking lot in Minnesota, which happens all the time. They're very normal cases. This gentleman slipped, fell, hit his hip, had internal bleeding as a result of it, and because of the condition that he was in at that point, it caused that damage to his hip caused his pre-existing kidney failure to go into a dialysis situation, which turned into him needing a transplant, a kidney transplant. Okay, so we went from a slip and fall in a parking lot in the middle of a Minnesota winter, which is a run-of-the-mill case, to a case where he literally had over $1 million in medical costs as a result of a kidney transplant. Okay, that's the great example of the eggshell doctrine case. I hadn't thought about that doctrine too much, but I had to go back to that. Now, that was a case where they were potentially trying to claim punitive damages. But that's the kind of case that I spent a lot of time as a defense attorney working up the analysis of why $1.5 million or $1 million or whatever it was in terms of medical expenses doesn't necessarily relate to $1 million in damages. You know, and again, you went back to some of the things we talked about: subrogation interest, lien interest, everything had been paid. You know, what was this guy really out? And again, what were the causative elements between his pre-existing kidney failure and then being put over the edge, so to speak, to need dialysis and then to need a kidney transplant? And again, I had to hire 3 or 4 different expert physicians to examine that because there were different nuances to that. I needed a kidney person, I needed an orthopedic person, I needed someone to give opinions as to, you know, if he would have got there anyway given his condition. But again, that's the perfect case that demonstrates an issue like the eggshell doctrine. And again, I hadn't thought a lot about it before I got that case, and then went, oh my goodness, what a mess. Liens and subrogation, and again, you have to know how this works. And if you don't know how it works, you need to consult with somebody how it works, because trying to settle a case or trying to take a case to trial and ask for quote unquote new money, you need to know what that new money is going to be. You know, how is that going to go through the filter, as I talked about before? You know, are there lien rights, subrogation rights that a medical provider, for instance, is going to apply? Is there negotiation that needs to occur beforehand? As I mentioned, a negotiation opportunity. Is there Medicaid and Medicare limits? The case I just mentioned, we had that overlay to it. But the point here is, you know, to Chuck's point, you don't want to get to a mediation in a personal injury context and then start thinking through, okay, they made a pretty fair offer, I want to accept it, but what am I really going to get out of this as the plaintiff, as the client, when all is said and done? The last thing you want to do is set their expectations it's going to be X and then say, oh, by the way, we've got to pay all these other parties that have subrogation rights or lien rights, and really when you filter it down, it's going to be less. Maybe you're going to want to involve them to a certain degree in the mediation. I've seen cases in the personal injury context settled where an attorney is going to take a third, the plaintiff's going to take a third, and then a third is allocated to lien rights and subrogation rights, and obviously the providers are taking a haircut too, but it's better than nothing. There's nothing more frustrating when I go to a mediation. And again, back to Chuck's point, you know, if I'm the defense attorney, I want to ensure myself that the plaintiff's attorney has thought about this, because you're not going to have a successful mediation if the plaintiff's attorney hasn't thought through how this is going to work, because you can offer anything you want. If they don't know how it's going to filter through, it's going to be tough to settle the case, and then you're sitting there frustrated, which is exactly what you don't want to be. And you know, I had a case recently that occurred. It's still scheduled for trial. It's a case that should settle, but it didn't settle because no thought was given to that on the other side. Even when it was brought up, it still wasn't given thought. There is an absolute opportunity in that case to go and negotiate with those lien holders to see if there can be a reduction made, yet nothing's been done, and it's, again, very, very frustrating. My point on all this is for both parties to be acutely aware of how this works, so you're not sitting there at a mediation, you're not sitting at trial trying to figure this out on the fly. Now, I talked about non-economic damages a little bit, and now I want to talk about it in more detail. You know, disfigurement, disability, loss of enjoyment, loss of life, loss of consortium. Again, these are ones that you know, these are ones that are going to be much tougher to quantify, and of course it's going to be something that you may need expert testimony on. You may need to consult with an expert to determine how to best present this. How is this going to work? What are the expectations if you have a disfigurement or you have a permanent injury of some sort that's going to result from that? And you know, if you have that kind of case as a plaintiff, obviously you want to involve someone who can work the case up with you to get there. That's not something you're going to want to do later on. But you know, someone who has experience with that, who can bring you back and say, based on this, your loss of earning capacity is this. Based on this, your medical expenses are going to be X. Based on this, your life expectancy has been cut. All those sorts of things. And then considerations. What jurisdiction am I in? What is the nature of the injury, the life expectancy, as I mentioned? I'll spend a minute talking about visuals. When I started practicing, a lot of the visuals that were done on whiteboards or done by PowerPoints, or not even PowerPoints, the old use of an overhead projector. The amount that can be done with a visual, and again, you want to know what the court's rules and restrictions are, and from an evidentiary perspective and all that. But assuming you work through those issues, what can be done from a visuals perspective to quantify non-economic damages is unbelievable. And again, that's something that can be put to a jury, and if it's done well and done right, can be devastating in terms of the presentation. What kind of testimony am I going to need? And again, there's some feel issues as a trial attorney. Am I going to ask for all this stuff? Am I going to look like I'm trying to win the lottery? That sort of thing. What are the comparables that I would have to bring to this? So there's a lot to think about, and I'm not giving justice to any one of these topics, but I'm just trying to give justice to some of the things that have to be thought about in terms of non-economic damages. And then we get to moving from non-economic damages to pain and suffering. And, pain and suffering. So I have there a quote from Texas law: permits juries to conclude from general experience, common sense, that someone suffered pain. A jury has wide discretion considering circumstantial evidence of pain and suffering and arriving at a sum. Pain and suffering recovery must be premised on conscious experience. Future pain and suffering must usually be proven with reasonable certainty. So, again, my point in providing those citations is that you're going to want to know in your particular jurisdiction, as applied to your particular case and overlaid to your particular facts, overlaid to your particular client, how this is probably going to work, how you think you can establish this. But again, this is the great wild card that as a plaintiff's attorney you can have. You have in a business case, usually you can sit down, work through it in a spreadsheet, work through it, your damages, and you might not be able to get every last number with exact certainty because there's estimates and there's other things that are going on, but you can usually sit down and figure out, what is my worst case going to be? Or what do I believe my range of worst case is going to be when I get to trial, or when I get to the end of arbitration? And I could sit down with my client and explain to them, based on all this, we looked at all the damages and we think your worst day is X. And again, you can apply that to a mediation situation, and the mediator says, well, you're going to be, you have a potential for a bad recovery. Yes, we know that, Mr. or Miss Mediator, but we've gone through all this. This is different with pain and suffering. It is a wild card thing, and again, it has to be proven with reasonable certainty, but the amount that can be requested is much more amorphous, much more nebulous in terms of what can be asked for at trial. And I think about trial, there could be arbitration, but typically arbitration is more business disputes, and pain and suffering generally is not something that's going to be in a business dispute. By the way, if you have an unsophisticated business owner client who doesn't understand the difference between contract type damages and damages that are generally established in a business case versus pain and suffering, you certainly want to educate them on the difference between the two, so they're not getting to court or getting to arbitration and saying, this has taken a toll on my health, this has taken a toll on my well-being, this has taken a toll on my mental state, and I want that, and you realize, no, that's a tort-like damage recovery that's not going to be recoverable in a business type case. And again, I've had plenty of business clients who believe that that's something that should be allowed, and I've had plenty of conversations where I've had to tell them, no, that's not something that's going to be recoverable absent some sort of personal injury. Now, even from there, you want to look at, in that context, if you have a personal injury, if you have, whether it's physical or mental or whatever, what are the levels that it's going to need to get to this point? What are the physical manifestations? what are the other pieces that go into that to make sure that you're putting this together correctly. I mean, again, I go back to my point to begin with, which is damages can sometimes be an afterthought. We all know, hey, there's going to be damages. It's a personal injury case. They have medical expenses, they have lost wages, they're out of work, they have replacement services, they have all these categories, but we don't sit down and do this. With future pain and suffering, again, it's both an art and a science to not only are there objective inputs into the pain and suffering piece to get at a number, there's also going to be the subjective piece. There's also going to be the experience level of who my judge is, who my jury is, who my audience, I like the analogy of going to the grocery store and looking at the 6 people in front of me and the 6 people behind me and saying, wow, that's going to be my jury. And again, that can be very different from county to county. It can be very different from jury panel to jury panel. But that's something that needs to be explained to the client when they say, hey, I've got a great case for future pain and suffering. Well, okay, but you're going to be putting this to 12 jurors in a very conservative community who's not going to, they're going to say, hey, I'm fine with paying medical expenses. I'm fine with paying lost wages. I'm fine with future lost wages. I'm fine with future medical. I'm fine with the quantifiable. But this idea that there's going to be pain and suffering both past and future, past, present, and future, I'm not okay with that. And so you're going to want to make sure, depending on what jurisdiction is, depending on the jury, you may even want to do some jury research to know how those kind of cases are going to come out. What am I going to need? If I have a whiplash, neck and back, personal injury, rear end auto accident case, do I have any chance of recovering big pain and suffering damages if the person can go to work every day yet their back hurts and it just impacts them but doesn't impact them enough where they're not working? You take the extreme case, somebody's been paralyzed or somebody has huge life-changing injuries. Obviously those are going to be the easier cases to put this together for, and again, those are the scary cases for defendants. The point will be, what kind of future pain and suffering, what kind of non-quantifiable damage can I establish in a more mainstream personal injury case? How is that going to be presented? How is my client going to be perceived when they ask for that? It's funny because I see in those kind of cases an inverse relationship between, if you have a plaintiff who has moved on with their life, who is doing well, who has not let the injury sidetrack them, yet can explain, hey, these are the things that happen to me every day in my life. I have to get up and stretch. I can't sit for a long period of time. I have other impacts. I have to take these medications. I have to do these things. I have to go for treatment these times, yet I'm still trying to carry on with my job and my career and my family and other activities. That's generally a better plaintiff than somebody who's sitting at home watching daytime television feeling sorry for themselves, yet wants a big pain and suffering award. So again, it's something that has to be looked at and sized up relative to both a plaintiff's case and a defendant's case.
Where you'll see that come up, some of the things Jim identified, it goes really all the way back to some of the first things that Jim was identifying in terms of analyzing a case when you first are confronted with it. Again, this could be in the personal injury context, a business dispute, or a host of other circumstances, identifying, he mentioned statute of limitations and a host of other things you're going to kind of run through so you have an appreciation for kind of what you're dealing with. So in the pain and suffering context, right, you're going to try and line up as early as possible all the different indicia of the impact this has had on the injured person. If you're on the defense side of that, you will similarly start identifying the things you're going to want to kind of evaluate to determine the breadth or scope of the potential pain and suffering exposure your client may suffer. Correspondingly, in the business context, there are other issues with damages that in that initial case analysis will come up. And they can be kind of quirky, and like Jim said, very jurisdiction driven. And not only may they impact the type of claim you wish to pursue and managing the expectations of a client in terms of what legitimate recovery can come, but it could also govern even advice that you give. For example, I'll give you a couple examples just that pop up in the commercial leasing arena. In a Georgia commercial lease, there's no obligation on a landlord to mitigate their damages. So if a tenant breaches, they can just sit back and then ultimately try and recover the swelled amount of unpaid lease amounts. That may or may not be a good idea for a variety of reasons, but mitigation's not a factor.
That's the same rule as in Minnesota. Right.
But mitigation is, in fact, an obligation on a claimant in a variety of other circumstances. So again, depending on what side of the V, if you will, you're on, the concept of what you must do to minimize or try to kind of get your arms around your damages can or cannot be important. So taking all of your possible claims, so that's from step one this morning and kind of articulating what issues you have, seeing through on day one what types of damages are at least possible, and then what work is necessary to achieve a good result on those damages if you're a claimant. And similarly, someone walks in your office and says, I have this problem, what might happen, knowing, where the exposure may lie, will help you assess the best way to tackle a problem when the client brings it in.
Chuck, on that point about using the example of the commercial lease situation, so the law in Georgia sounds like it's just the same as the law in Minnesota. And I literally was looking at that issue last week for a client, and of course that melds the legal with the practical. On the one hand, hey, the law is that you don't have to do anything. You can sit back, as you said, and collect your damages. Now, the practical is you probably want lights on in your stores, and so maybe that's not the best business idea. You probably want to go engage a broker. You don't want to be the test case for a court to change the law and claim this is unconscionable because you sat back and did nothing. So I always, for instance, in that situation, encourage landlords, go get your broker involved. Go try to rent the space. Use best efforts and say, Your Honor, not only does the law not say that we have, the law says that we can recover this, but despite all that, we tried to mitigate. We took all these efforts, we did this, and now you're looking good from both sides of it. Let me just finish this last slide. So I'm talking about pain and suffering, and again, non-pecuniary loss can be supported by a plaintiff's own testimony, and that's the scary piece that it can be applied. But there's also the melding of subjective and objective, things like life expectancy tables. So it's both an art and science about how those are put together. We're now going to turn back to Chuck and talk about discovery and evidence.
Thanks, Jim. So after Jim identified for you damages issues to consider, both different types of damages, limitations on those damages, you can kind of start to see how the outline from the beginning of the day of assessing a case, identifying potential claims, flaws with those claims, or on the flip side, the defenses really start to take shape. Now we're going to spend the next session talking about discovery and some evidentiary issues associated with discovery as we try to harness all of the information that you've been hearing throughout the morning. You should go investigate such and such. You should figure out how you're going to establish your damages, and different other issues that come into play during a case, maybe that you'll use at mediation, maybe that you'll use at summary judgment, or ultimately at trial. So let's dive into discovery. This is a fairly lengthy section because most of what me, Jim, and other litigators like you do is most of our career is spent on the discovery phase of a case. So let's start with some of the basics. So the written discovery vehicles that we most often see are request for production of documents, interrogatories, and request for admissions. And those are things that obviously are from one party to the other party, but we also need to keep in the back of our mind the capacity to obtain discovery from non-parties through subpoena efforts and the like. And I'll talk a little bit about that as we kind of run through. As dry as written discovery may seem, it's really the backbone of the successful push prosecution, or defense of any kind of civil case. So I've kind of given a juxtaposition here with respect to interrogatories and the other written vehicles between the federal rule on the one hand and the Georgia rule, just to identify the possibility that a local jurisdiction may have a contrast with the way written discovery is approached. As I mentioned earlier, in arbitration, when discovery is afforded, it most typically is done in a circumstance where the parties have great input and control into what discovery is permitted or any limitations on it. There really are no specific hard and fast rules about written discovery in the arbitration context, so most of this will be done or kind of presented in a manner identifying when you're in a traditional court system, the different approaches that are available and the strengths and weaknesses of those. In the federal system, the interrogatories are capped at 25, including all subparts, which seems like a drastically low number if you have both a sophisticated case or you're trying to do what your supervising lawyer tells you to do, which is go find out all of this, and that list is really long. But if you recall, in the federal system, there's been an initial disclosure layer placed on all parties in cases where the lion's share of what we'll call the rank and file interrogatories, those kind of boilerplate ones about identifying certain witnesses, identifying certain documents, identifying even certain measures of damages, are required of parties, so there's no need to burn what otherwise would be a traditional interrogatory on some of those, which gives you then additional license to be surgical and creative in drafting interrogatories to try to really hone in on precisely what it is you're looking for. In the written materials, I give some examples of some of the kind of the boundaries, if you will, in drafting interrogatories, and there are some competing principles in play. You have kind of the motivation to make sure you don't leave anything out, so that any and all kind of phrasing kind of permeates a lot of your written discovery requests, balanced with trying to be very surgical and get right to the quick, so that you're not buried with a bunch of kind of mundane objections or kind of led on just a very general kind of gloss over items kind of response. You see that a lot in the request for production of documents phase, where you look for that any and all, and then you end up triggering an avalanche of responses or an objection that the response would be an avalanche of unreasonably broad information, when, in truth be told, you're really dialed into looking for a particular subpart of document descriptions, and you need to balance the A document versus all documents. No huge rule of thumb. I tend to kind of shift myself to the all kind of side of things, in particular because then it takes the guesswork or even the control away from the responding party. If I were to ask for a document that deals with some contractual issue, I may trigger a response, but it's not the A document that I like, it's the A document chosen by the opposing party. Inside of the written discovery field, the interrogatories, especially requests for production of documents, most of us have seen kind of the run-of-the-mill boilerplate objections that are trotted out, and then only after this long list of standard objections is there any sense of something that might even be vaguely or generously characterized as a substantive response. The subject to the pages and pages and pages of objections that I keep repeating, I'm about to identify for you a portion of my actual response. I'm being a little tongue-in-cheek, but I don't think that's a far stretch from some of what we've probably seen over time. There is a trend. I'll tell you, most of the federal judges in Georgia have gone this way. They have standing orders that absolutely prohibit the stock set of objections for written discovery. really forcing you to think long and hard about what's objectionable about it. And then they all have rules identifying your obligation to either produce or identify what is not being produced and give particular justifications as to why. Making something of the past, the preparation of the response on the 27th, 28th, 29th day, dropping a bunch of objections in there largely because your client says, I'm not turning that over. That no longer is going to stand. And what it's done is it has eliminated a lot of the discovery practice where you're writing letters back and forth complaining about inadequate responses, burning up valuable time, valuable resources, and then only a month or two later down the road does anything resembling a coherent response start to surface. Meanwhile, your clock is ticking for you to comply with all of the other discovery that you need to do in a case. One of the forgotten tools in the discovery kind of toolkit, if you will, is the request for admission. Done poorly, it really is just printing paper for paper's sake. Done right, they can be incredibly valuable. And it may not be that the request for admission is a tool that I would encourage you to use in all cases, or that you would use really early in a case. That's going to be something that you might want to kind of bounce off other folks in your office, or by experience start to trust your instincts as to when the request for admissions are something that you should employ. For example, as your case has moved forward slightly, that may be a good time to send out a set of requests for admissions. Maybe after a principal deposition where kind of the boundaries or kind of the rules of the road, so to speak, have been staked by a witness or two identifying, really what happened in this event, contractual dispute or otherwise. The request for admissions can start honing people in on really what's happening here, particularly as you look downfield towards substantive motion practice. So if you can establish a certain principle up front and not have to waste a lot of time with it. Or don't forget the use of a request for admission at trial. Jim alluded earlier to, in the presentation of damages, the benefit of using some kind of visual to help give people a lay of the land in experiencing and kind of being able to frame an appropriate damage recovery. The request for admission is a spectacularly powerful thing to put up on a screen when you can say, the other side has already said the following things are true, and you can just kind of lay them out. There's actually an interesting case from a long, long time ago in Georgia, long enough that it would happen not long after I started practicing, but I've never forgotten it. Big row over the use of requests for admissions, because if you remember, even in the federal rules, there are limitations on the capacity of a party to object to a request for admission. It's not like an interrogatory or a request for production of documents. And the Court of Appeals in Georgia, in a discovery battle, ruled that a request for admission was properly drafted, and the import of that decision was that, at least in Georgia, a request for admission can be a mix of law and fact. Think about some of the objections we have all probably used in the RPD or interrogatory context. We're going to say, well, that calls for a legal conclusion properly drafted, at least in Georgia, and I think several other jurisdictions fall in line with this, is if you're articulating a concept and applying it to the specific facts of your case, that is a proper use of a request for admission. Hopefully you're going to get a coherent response from the opposing side, favorable or unfavorable. They may just outright deny it. And Jim identified, keeping an eye on some of the fee recovery capacities that may be present in a case. And if you have to expend a certain amount of money proving a fact that should have been admitted in a Rule 36 request for admission and it was improperly denied, that's a recoverable path. It won't be all the fees incurred in a case, but again, it's just one more thing you can kind of throw into your group of potential weapons to use. The written discovery, it is, there's nothing that I can do, Jim can do, or anyone can do to really make written discovery kind of sexy or exciting, but it is crucial. It really helps to set up a lot of the other things that you're going to do in the case that may be more entertaining and more invigorating, but without adequately and properly done written discovery, it's almost impossible to be effective. In the never say never category, my standing rule is to never file a case unless I'm going to accompany the lawsuit with written discovery. One of the advantages even Jim identified in this, hey, what if they file a competing lawsuit in another jurisdiction and beat me issue? One of the advantages of being a plaintiff is you get to go first. So why not start discovery first and force the other side to sit down and really, kind of spend some time, and it's not just to grind fees, but to really spend some time articulating what their position is and how they got there. And so I'm a huge proponent of serving some discovery up front. One, because you're given the opportunity to go first, so why not take it? And then also, if nothing else will force you to sit down and really think through your case, run through Jim's checklist of things to do as you're assessing a new matter and a new client, preparing the written discovery that goes with your lawsuit should. That is, literally, client, what do we need? What do you think the other side has? What are the things I'm going to need to get from them to help me put together the most coherent and effective story that I can? So if written discovery is not all that interesting or all that scintillating, then here's the extra scintillating part, e-discovery. Something that had not even been invented when Jim and I started practicing, but it is now such an inherent part of civil litigation that the American Bar Association and its rules of professional conduct compel all lawyers to understand technology inside of the description that you must have the requisite knowledge and skill to handle a matter. So although I have no business maybe handling a case in a certain subset of a practice area, similarly the ABA rules say I'm not supposed to be handling sophisticated civil litigation unless I can tell a client that I'm up to speed with the ongoing technological vehicles that are out there and the impact that that may have on handling what otherwise may be a fairly garden variety business dispute. And as you can imagine, the e-discovery platform and the issues associated with it really are almost endless and could probably be the backdrop for an entire day of seminar to really get an adequate description of everything that falls under the general description of e-discovery. I'll do my best to not make this totally boring because we are talking about written discovery and specifically e-discovery, but also to hit on kind of some of the highlights. So this ABA rule says to you, me, Jim, and others, you need to understand technology as part of your ability to do your job. What are they talking about? One is going to be generally just being familiar with social media platforms. And generally, I do not profess to be the IT professional in my office, but just understanding certain differences between what a desktop is, what a laptop is, what flash drives are, what cloud technology means, and how those interrelate are all things that you need to be able to do. And we'll get to some specific examples of where that knowledge is going to come to the forefront as you try to dive into the discovery phase of any civil case. Let's talk about this from kind of a negative connotation. That is, what if you don't know what you're doing with ESI? Or what if you don't properly handle it, which normally will come from not really having a good understanding of it. We could rattle off a list of cases decided in the last few years where parties or lawyers have been tagged, that is sanctioned for not properly handling electronic information, or ESI. That could include, rulings that evidence had been destroyed, or a spoliation charge, fee shifting mechanisms for the other side to try to fix the problems that you created because you kind of bumbled and fumbled your way through it. And then there's always that inherent pall over your case. Jim talked about this in the context of some damages where an opposing party may have overreached and it kind of, as he said, infected the rest of their case. Once a judge thinks you're a screwball and you have not gotten your arms around ESI in a way that is appropriate and can identify how it has impacted the opposing party's ability to defend themselves or to prosecute a case on their behalf, don't think for a second that's not going to affect a host of all other things in the case. So let's dive into some ESI. You have a case, discovery is about to get going. What do you need to be doing? One is talk to your client. That's really one of the starting points, right? Is to figure out what your client has in the realm of what is considered ESI, electronically stored information. Catalog all the sources of this information. Instruct your client to stop using certain devices or accounts until proper measures can be implemented so that that information no longer becomes tainted, deleted, written over, or anything else. And so on that section, instruct the client. Most businesses, even if not large enough to have, think of a larger company with a chief technology officer. You're going to say, oh, my client is a smaller business. It's, name somebody. It could be a landscaping company. It could be a home remodeler. You're going to say, all right, but somebody, everyone has the computer guy. When stuff's not working, who are you calling? You need to put that person in the loop. It could be the outside IT consultant or somebody, and have them explain to you what data exists, where that data sits, how it's created, and how it's maintained. And then it could be simple things. Hey, IT guy, do you have a couple old desktop towers that are just sitting in a closet that aren't being used anymore? Yes. Can you give me a list of every computer on which the company is paying for an Excel license or a Word license or a, QuickBooks license? That's going to give you an inventory of how many devices may be in play. Those are all starting point, kind of basic questions. You don't need to be a computer guru to start probing along there so that you understand what it is you're dealing with. I strongly caution you, do not rely on the manager of some division office to be able to explain to you what their computer system or their IT network looks like. For the same reason that you don't want me explaining to you how our firm's network works, it could be a little bit of the blind leading the blind, right? So let's cut to the chase, get somebody involved who really knows what's happening, because once you know what you're dealing with, that's going to give you the capacity to help come up with the adequate solution. So let's use some examples. Salesperson has an iPad or a laptop that they're using all day, every day. To tell them to take that out of commission while the case is ongoing so that none of the data on there gets corrupted, you could do it, but the clients aren't going to like it. It's hugely ineffective, and frankly, it's unnecessary. So then you bring in someone to image your computer, so that you always know what was on there on a certain day. And then if the person goes on into the field and uses that laptop going forward, they're not doing it with fear that they're putting the company or you in harm's way because they've overwritten data. And there are plenty of companies out there that can help get those things properly imaged and cataloged in a way that will suffice any judges scrutinizing over whether you've adequately handled information. in sending in an outside service to do some of that computer imaging. It's really not very expensive, and any expense paid out will only come back tenfold when you compare it to how bad your life can be if it's not done right. And that expert sometimes can help you appreciate what it is you're dealing with. And Jim had talked about this in a couple other contexts about the necessity of putting in writing to your own client kind of what it is you're doing and why. Send to the client kind of a preservation letter explaining all the steps that are necessary, and make sure you follow up on it. This is not anything to be taken lightly. This is the new norm for civil litigation, as evidenced by the fact that even the federal rules of civil procedure have been updated to specifically contemplate a lot of the steps that I'm describing. So if you weren't taking it seriously before, now that the federal rules specifically command all the parties to take certain steps, now is certainly the time to kind of get up to speed and start taking those steps. If you can do that with your own client, which the ABA is telling us we all have to be able to do, then your ability to communicate with the other side should be similarly facilitated. Once the opposing side files a response or has a lawyer or something, the federal rules even contemplate a dialogue between lawyers to have a discussion and come to an agreement about the breadth, scope, and depth of ESI. What are we going to do in this case? There's a strong encouragement that the parties agree what protocols are and are not necessary. And again, that's going to be very case specific. And the type of dispute itself may drive just how far everybody is motivated to go in handling ESI. I told you it wasn't exciting, but it is, like I said, the new normal. It's a big deal. One of the things our firm does is we litigate a lot of trade secret cases. You stole my client list, you pirated a group of customers or some idea or something else. So the preservation of data is absolutely crucial. We start imaging things right off the bat so no one can accuse our folks of having done anything wrong. And similarly, we put massive demands on opposing parties to try to lock down data as quickly as possible. And then the forensic folks have an opportunity to go in and trace steps and follow literally every keystroke that may have been hacked into a particular computer, and to demonstrate that in fact so-and-so did flip stuff to Dropbox, miraculously at 11 p.m. the day before they left the company. It's maybe not always that obvious, but that's just a good example, very basic, good example of where kind of having harnessed all the ESI can really be utilized for defense or prosecution of a case. Where you can also see it, if you do adequately get all of your information under control, is it can head off the accusation, again in my you stole my trade secret or you stole my client type context. It may be that you can demonstrate precisely what data was or was not touched, and that may have an impact on how the case is assessed by everybody and kind of where it goes. But it doesn't have to be even in a complex business. You took my whole sales team kind of case. Jim was talking about kind of a run-of-the-mill slip and fall case that he dealt with. It comes up in that context too, and actually that's where acting swiftly is hugely incumbent on you as the lawyer to try and get involved. Circuit video is very easy now. Anyone can buy a home or business kit and install a video monitoring process. The days of videotapes are probably long gone, but it's all just being written onto a computer. Most of those programs are defaulted to just overwrite the same data on some timed interval. because assuming that your business wasn't broken into a week ago, there's no need to maintain that videotape of the parking lot in the middle of the night. So it's logical that it would be set up in a way just to be overwritten. So that's an example of something that's very basic, that in this ESI gathering, we would need to figure out what kind of information exists. So to wrap up kind of on with your own client, right, you have written engagement letter telling them that they need to cooperate and how to work through with you on discovery. Investigate their platform so that you can identify the scope of ESI. Follow that up with a preservation letter to your own client detailing what their obligations are. Then from there, that's your jumping off point to focus your attention on the other side of your dispute and sending some kind of preservation letter to those folks, alerting them that they are custodians of information and that because there's a dispute, it's incumbent upon them to maintain all of that information. From there, you can use those steps throughout the discovery process to monitor someone's compliance with that. As much as I was identifying the fear of being accused of spoliation because the consequences inside of litigation, whether it be adverse jury charges at the end of the case at a trial or anywhere else, similarly, if you can start putting that pressure on another litigant in the case because they've not taken it as seriously as they should, that is a pretty commanding hammer to have that can be wielded throughout some litigation. So we bored you with all the e-discovery stuff, and I put up on the screen here, a host of different platforms that you need to be aware of. Are people throwing stuff through Dropbox? And there's a host of other outfits like Dropbox where people are sharing information. I think you'll find that sales teams use Dropbox a lot. They're out in the field, they want their clients or customers or potential clients to be able to access a bunch of information. So they're sharing it through vehicles like that, and just knowing how those work and asking those right questions will then lead you to what information you need to be getting from other people in the case. I've identified other platforms, whether it be Facebook, LinkedIn, Snapchat, Instagram, and a host of other places that you need to kind of go ask people, has anybody been posting it? Does anyone who's involved in the case have these types of accounts? And kind of start sifting through. All those ESI steps I described, as mundane as that may sound, just before that I was identifying the need to tailor and craft some written discovery vehicles that match the issues in your case. I've just done some of them for you. In interviewing your own client, you're being told, for example, that your sales folks use a couple of these platforms to share information with potential clients or existing clients, or that some of your folks they reach out to potential clients or make sales calls, if you will, using LinkedIn groups. All of a sudden there, I've just handed you certain written discovery requests that you need to follow up on that are certainly very case specific. I'll give you a little war story. Everyone likes telling war stories about themselves when they worked. No one tells any war story that ends with, yeah, and it didn't work for me and it really went badly. I was trying a case I inherited from another law firm where discovery was over. No depositions had been taken in the case for a variety of reasons that still don't remain entirely clear to me. But so we're going to go try a 5-day jury trial with no depositions. One of the issues in the case was someone was contending that they lacked the mental faculties to have entered into all the business agreements they were being accused of having breached. Kind of a capacity defense. And one of the things that we found was within the weeks surrounding one of these contract signing days, if I told you they're all signed on June 1, then maybe later in June or in July, this person and other members of her family had gone to Las Vegas. one of the things they did in Las Vegas was they went skydiving. And one of the kids had posted a series of these pictures on their Facebook account just because it was kind of a neat once-in-a-lifetime type event. And one of the things that they posted was the big placard that's, I've never been skydiving, but I can assure you that I know it's there, the one that says, everyone recognizes this is hazardous, and you need to follow safety precautions, what have you. And we all know that no one's going skydiving without signing a very lengthy waiver that something bad can happen to you. The waiver we never got our hands on, but we used all these other pictures. We pulled them off of Facebook to try and describe if this person was coherent enough to understand what they were doing by going skydiving, including this "you will die from this activity" sign that her daughter had posted. How dare these kids would let poor mama ever do this if she really was kind of out of her mind, so to speak, to demonstrate that she actually must have had her faculties when she was signing this multi-million-dollar contract. We ended up winning the case. I don't know if it was because of that, but not miraculously, the morning of trial, one of the paralegals in our office checked the Facebook account because we had exchanged exhibits just a day or so before trial, and the Facebook account was inactive. They had taken it down, but they had taken it down just a little too late. Kind of a neat use of Facebook. It's something that we are pretty good about doing, is kind of channeling down all of those little rabbit holes, because you just never know what you're going to find.
Well, and conversely, you need to talk to your clients and say,
Jim, you're on mute. Go ahead.
Conversely, you want to talk to your clients about preventing them from providing those tidbits to opposing counsel and the other side. And I have that conversation with clients from time to time about social media, and it's not, hey, I'm not the fun police here. On the other hand, you're involved in a lawsuit, and there can be documents that could go from privileged to unprivileged if you're texting your friends about communications we had, or you're putting things on social media or any of those kinds of things. You just need to be a little more circumspect in what you're doing when you have the overlay of a lawsuit in your life versus not doing so. Now, I think that's good advice generally speaking, but it's certainly the case when you're dealing with that, because I've had the same experience as you've had, Chuck, which is I've been able to mine things from social media that I shouldn't otherwise know, because people just have this disconnect about their personal life versus their business life. And of course, as lawyers, we don't think of that same way.
So we're going to jump all the way from some of these written discovery things, all the way for a little bit to, frankly, the funnest part of it all. I am very fortunate that even in the business context, I get to try at least one week-long jury trial a year, and have for many, many years. At least in Georgia, that's exceptionally rare. Maybe I need to be listening to myself about the benefits of mediation more or something, but I've actually been able to put a lot of these discovery tools to use in the trial context. And the reason it's applicable, even though we're talking about kind of a pre-trial focus for a seminar, is everything that you're doing has to be against the backdrop of how is this going to get into evidence at a trial, right? So Jim touched on, for example, damages. Yeah, it's a good story, but does it work legally? And then do you have the bona fides to fulfill all the requirements to get that certain recovery, for example? And that includes, how are you going to prove this stuff? You're collecting all this evidence, whether it be non-parties. I didn't really touch a ton on that. That includes your open records requests to governmental agencies. And please never minimize the advantage of using open records requests, whether they're at the local level, the state level, or at the federal level. There is just an amazing amount of information out there that can be utilized, gained pretty swiftly, exceptionally inexpensively, and that's something that you really need to kind of get around. But even if you're successful getting that kind of information, what are you going to do with it? Is it admissible? One of the better or worse days in my career. I was getting a case ready for trial. I had this exceptionally talented associate. We were kind of talking through evidence, and I just kind of asked. It was a case, he was sophisticated enough, he had done a lot of the discovery himself, it was going really well. But I asked just the basic question. Well, that sounds good, but how are you going to get that into evidence? Just because it was a document that had been present at a bunch of depositions does not make it itself admissible. You can talk about whatever you want at a deposition, right? And it was one of those kind of like aha moments for him, and it's a lesson I learned a long time even before that was, all right, I'm standing here with a piece of paper, a picture or something. How am I literally going to stand up in a courtroom, start talking about it, and either A, not get yelled at by a judge because it's not in evidence, and get it into evidence so it can go back with a jury. And there's the rank and file, there's the easy stuff, right? Foundations that we all learned in law school and everything else. But there's a host of other interesting information out there that can really have a great impact on a case. And I'm just going to touch on a lot of these again. We could probably go identify any one of these as being the platform for a very lengthy section or discussion in and of itself. So character evidence. I think Jim was alluding to, clients coming in and talking about, well, I want to be compensated for my time for this and time for this. Similarly, you're going to have clients telling you stories about, that so-and-so, let me tell you about him, or let me tell you about her. And understanding when kind of some of the gossip can be turned into real evidence can be hugely effective. We've identified here some of the some of the federal rules of evidence on character evidence and when it's appropriate. Generally, you're talking about truthfulness or untruthfulness, using reputation evidence, opinion evidence, or specific instances of conduct. And there's a host of cases that kind of talk about exactly what all of that means. The general platform, though, is that character evidence is normally not admissible. Whether I breach the contract really doesn't turn on whether I'm a bad guy or whether you can prove that other people don't like me. It's simply that the contract, I promised to do the following things, and I either did or didn't do them. It'd be pretty fun, frankly, if you could get that in every time, but it would all just turn into kind of a playground mud smear campaign. But it wouldn't lack for color or interest, that's for sure. So the things I was identifying, there's of course criminal conviction things that come up, but there are times when reputation evidence and so forth is permitted. If there are cases involving fraud, that tends to be an instance where character evidence is more likely that it's going to be something in play. And I'm going to touch on motions in limine later today, but the motion in limine is a vehicle on character evidence that I cannot emphasize enough how powerful it can be. Because the use of some character evidence, presumably it's going to be that the person against that you're against in the case is of bad character. I mean, that's normally what we're talking about. It can be so monumentally persuasive. Those are all the reasons that it's generally not allowed. Your capacity to get it in can be very impactful. So your ability to push a case knowing you can get that information in, you'd rather know. You don't want to learn on day 3 of the trial that the judge doesn't want to hear anything about that, and you had been banking on getting that in. Similarly, if your person's bad stories are coming in, you need to know about that well ahead of time so you're not dealing with it on the fly. And that motion in limine process is where you're going to figure out what is and is not coming in. That brings us to somebody's habit. This is easier to get in. Federal Rule 406 speaks to habit, so this is kind of habit and custom. Think of this: if someone in your organization routinely does the following set of protocols. That is, I'll come up with something mundane. The orientation of a new employee includes all the following forms and the following steps and so forth. If they can testify that that's their normal procedure in the right circumstance, if that new employee's forms cannot be found, you can establish that they likely went through those steps because your custodian is going to say, well, I always meet with the new employees and go over the following steps. That trade or custom type approach is going to require a demonstration that it's a regular occurrence. You have to demonstrate similarity of instances of other conduct, the frequency, the regularity, and so forth. The witness for that is going to be the one with the personal knowledge of the routine. It's inappropriate, for example, me to testify that so-and-so in my office always meets with the new employees and does the following 10 things, because I've now introduced a layer of hearsay that is corrupting the authenticity of the habit kind of testimony. Subsequent remedial measures. I'm jumping all the way into that, away from habit. That is Federal Rule 407. It's most commonly going to be in kind of your product liability or even a personal injury context, where after a catastrophic incident has occurred, new procedures are implemented. Although it can come up in a host of other places as well. You stole my trade secrets kind of cases that our firm tends to deal with. Suddenly, a company implements procedures where you inventory and check everyone out of the company and get their laptop, cell phone, and do all these kinds of things when they leave. Is that admissible that they should have done it earlier and their failure to do it somehow impacted those trade secrets having been stolen? I'll just come up with that as an example. And 407 talks about the balance, where normally that information is not permitted because otherwise you're really disfavoring companies implementing safeguards. There are, however, some exceptions to that rule, particularly if, for example, a defendant contends that it didn't control whatever vehicle was in place at the time. If the company says, well, we didn't have a way to inventory everyone's laptop and cell phone, and then suddenly they later start inventorying them, they've kind of opened the door for that to come in. There are a host of other evidentiary hoops that I'll kind of run through quickly here. There's writings, recordings, and photographs. Kind of jumping around a little bit. Photographs are probably some of the easier ones. You do not need the photographer to be your witness. All you're looking for is a witness who can identify that the photograph accurately depicts the scene or the event or the building, the car, whatever the item is displayed in the photograph. But the photographer's testimony is not needed. It just has to be an accurate representation of whatever the proponent claims is displayed in the photograph. Some of the other records, though, start getting kind of funky. And this is where there's a lot of kind of hay being made. Georgia had what I might characterize as a slightly out of date or antiquated business records rule. We've now implemented a rule that mimics the federal rules of civil procedure with respect to business records. So our steps have been amazingly simplified. We used to have a lot of battlegrounds over what constituted a business record, which obviously has implications in terms of how things are authenticated. You have certain things that are self-authenticating, newspapers, commercial paper, official records of the state, but a lot of them are not self-authenticating, business records being one of them. And the business records rule really requires someone to identify that it was created, maintained in the normal custom of the business. You're seeing that habit and custom concept come through again. There are certain other instances when you can go get documents certified. The open records request I was identifying earlier typically will come with a certification from whatever agency generated the records, and then they'll fall into that self-authenticating kind of rubric. Rule 8036 is our business records rule that kind of speaks to the maintenance of records by a business and a certification by the custodian, and it creates a path where you don't need actually the custodian to come in the courthouse. Thank goodness, right? You talk about slowing down a trial, and you talk about boring, is waiting for someone to come from a company, walk in and say, yeah, that's big box of records over there. Yeah, we made those records, we kept them, I printed them for you guys, as opposed to just being able to introduce them directly. One trial tip on that, however, is if you have that authentication process where you're going to eliminate the need to have, I always think about the person walking in with the golf shirt displaying the logo of the particular company. It's kind of an illustration, not maybe realistic. If you're going to eliminate that and you're just going to walk up with a box of documents, just start flipping them around the courtroom, I would encourage you to go through some kind of show as to how official these records are, because you've lost the person from such and such company who trots in wearing the company blazer or golf shirt, talking about all the steps that they have and they're paid to do this and it's part of their training and what have you. If you want these documents to have extra import, try and go through a little sideshow to demonstrate all of the steps that the federal rules of evidence that the U.S. Supreme Court decreed, were all complied with, just so that they don't lose the impact that they're designed to have. I'm going to buzz through only because it's hugely important, but it's something that is not adequately done by me just highlighting components of each of them, is the next section, which is hearsay. And you're going to hear a lot about hearsay if you try cases, what's permissible, what's not permissible. And I emphasize how I can't cover all of this adequately in the time allotted because there are 23 exceptions to hearsay that are articulated in the federal rules. So we could probably do just hearsay if we wanted to, but we won't. The out-of-state statement by an out-of-court declarant that goes to the truth of the matter asserted. We probably had that burnt into our brains after 3 years of law school. And then there are all these exceptions that are designed to identify when the out-of-court statement has the pall of credibility needed for it to be admitted without the actual utterer being in the courtroom. And there's a long list of them. They're in the written materials. A lot of them, if you saw them every once in a while, you may be surprised. And then a few of them are just pretty obvious in terms of the steps you need to go through to get certain things in. Records of religious organizations, marriage certificates, family records. A lot of those kind of things seem pretty basic. A couple that you may see, I litigate real estate cases, so there are specific exceptions dealing with the records of documents that may affect an interest in property. Records concerning boundaries are things that you can get in through some of these exceptions. We talked a little bit about character evidence earlier. So you have judgments of previous convictions, certain things like that. Vital statistic records can come in. Those are all kind of articulated exceptions to the hearsay rules. I want to talk a little bit about exhibits. Because this is something, Jim alluded to some of the stuff you really can't learn in law school and then you just start experiencing it every day. And this is one of those. Obviously, pre-mark all your exhibits. Find out from the court ahead of time the way the court wants its set of exhibits. Do they want them, put into like 3-ring binders? Do they want them, accordion filed? Some other system. And then this part, I'll probably say it twice just for emphasis. Maintain a comprehensive and accurate, of course, list of all exhibits that have been tendered and admitted, and note whether there was with or without objection. And the reason for that is, let's go all the way to the end of the trial. Before the jury takes anything from the witness stand, right, the stack of exhibits, the judge is going to say to you, go through all those and make sure that whatever goes to the jury should be going to the jury. And you're going to be standing there flipping through a stack of records, trying to figure out, was Exhibit 37 only tendered but never admitted, and all of that. And if you're just trying to rely on your memory, Good luck. You need to have an adequate log of them so that you're making sure the jury's not getting to view for a second time anything that it really shouldn't be. With that said, the other thing I can tell you is it goes incredibly fast at a trial, the tendering of information. That was probably one of the greatest eye-opening experiences I had when I first got to attend trials and then got to try cases myself, is documents are going up to that witness lickety-split. I'm going to show you Exhibit 23. What's that? They talk about it. Exhibit 24. What's that? And just being paraded out, and then the lawyer just starts turning to the judge and says, we move to admit Exhibit 23, and the judge is going to immediately look at you, and you have to know what 23 is, what's in there, if there's anything in there that makes you unhappy, that you want to object on, and what your objection's going to be, and so forth. And it happens in a moment's notice. And if you stutter and bumble around, it doesn't take long for everyone in the courtroom, including the jury, to realize that you really don't have your arms around what's happening in your case, and not only what the rules or the law is, but how it impacts your case. It just goes incredibly fast, and you just got to be ready for all of that. Last, I would tell you that obviously your objection has to be based in law. It can't be based just on, well, I don't really like that, or some of the kind of made up. Track your objection to a specific evidentiary rule, and just keep an eye on that. So I'm going to jump all the way back to the very beginning. But this morning, Jim was talking to you about assessing your case, gathering the right list of information, witnesses, and a host of things. You're trying to then engage in a damages analysis and do a comprehensive written discovery plan. All the while, every time you come into something, whether it be you've grabbed a picture off of Facebook, or you've gotten a record from the local planning and zoning department, or an opposing party, or a former employee, always make sure you have in mind how you're ever going to get this document into evidence. I said I'm fortunate that I get to try a good number of cases, a good number being a relative term. But evidentiary issues come up all the time. TRO hearings, summary judgment, everything that the judge looks at has to be admissible. So you're going to have your rules of evidence kind of mastered, even if most of your litigation tends to be focused on motion practice. Just stapling a document to a summary judgment brief because it was in a bunch of depositions is not enough. And I see too many people just kind of get lazy or slack about it. Just because something was stapled as an exhibit to the complaint does not make it admissible. So those are some things to kind of keep an eye on. At the end of the materials, I kind of threw in some recent cases, and they are designed, if I haven't scared you enough on ESI, to focus on some of the ESI rulings that have been coming down from around the country, because this is such a big deal and it's become implemented as a new component to the federal rules over the last number of years. Like I said, no one had ever heard of ESI when I started practicing, and presumably when Jim did. All the discovery we ever did, I mean, I just remember boxes and boxes of documents just being rolled in the door and plopped in the back of your office, and you would just cruise through them. There was no such thing as all of this ESI baloney. But it's the way of the world. It's very important. And there's a series of cases here identifying the impact of some spoliation concepts. And we highlight a couple cases out of the 11th Circuit in the analysis of what kind of prejudice came from the defendants not following adequate protocols, and a judge kind of hammering them on that. There was a more recent case that's highlighted in here. It's called HCC, is the name of it. And it involves, it's actually a great read if you want to read the case, in part because it goes through a detailed analysis of how a spoliation assessment should happen. If you claim that something was stolen or was destroyed, just the steps that this judge went through to figure out, did it happen, why did it happen, what was the impact of it. It's a really good primer on kind of how some of those cases or how that issue is kind of analyzed. And we've left a few other cases in here that also talk some about that issue. A couple other practical things to think about. This is, again, particularly in the ESI world, because this is, again, just something that we're all kind of trying to maintain our knowledge base of, is if you get a discovery request and the party says, I want it in native form, probably want to ask them if they even know what that means. And what you're talking about is the manner in which this information is delivered to you, and without going into, and I do not, again, profess to be an IT professional, the difference from the days when Jim and I would get documents sent to us, just print it out, put in a big box, tape the box, roll it over by a courier, and stack it in your office, and you just start reading through it till your eyes glazed over. You're missing, frankly, a lot of the backstory to that document, metadata. So if I were to show you an agreement, and you could look behind what appeared to be what I'll call the written page, it would show you who modified it, when it was modified, what they modified, who they then sent it to, and it could be that a certain paragraph was stolen, borrowed, from another document and dropped into it in terms of how an attorney's fees provision was implemented or something along the way. Seeing all that behind the scenes information is hugely important. And that's really why you want to get things in kind of a native form where you can start tying the metadata to that particular file. Think of the, it's kind of a cipher, right? Where it's a puzzle that you're trying to figure out who saw things, who forwarded emails to whom, and who opened the email, when they opened it. I mean, all of a sudden, a lot of that stuff becomes very important that you can't get from someone just printing the email and then printing the attachment and just stapling it all together and just giving it to you. So you want to be able to kind of tie a lot of those things together. So if you're a Da Vinci Code fan, that's a good reference, right, to just think about the cipher puzzles from that movie. That's how much data is shoved behind what otherwise looks to be a very innocuous Word document. One of the things I have a strong preference for is producing things in either a PDF or a TIFF production platform. It keeps people from messing with your information, but there is a way to produce that stuff, that being in the PDF or TIFF, and it maintains some of the metadata where it's not cleansed, so you do have the ability to kind of sift behind it. With that, I will leave with one parting comment in terms of all of this ESI business. I told you that it's been swallowed into the federal rules. The federal rules, they are not totally out to lunch. They have taken into consideration the very thing that's running through my mind and yours when you first start getting exposed to ESI is, holy moly, what if I'm representing the small fry up against the big company or something? There's no way this is fair. I'm going to get slaughtered. The days of the document dump are here to stay. There's no way I can keep up. And there's a balancing in Federal Rule 26B1 that talks about the relative expectations for ESI, including how the fees should be divided amongst litigants. It's not necessarily no one's necessarily going Dutch, if you will, where it's just split. It takes a lot of that into contemplation, and if needed, the judges are now very up to speed on making sure that the folks who have the ability to garner this information are being held with their feet to the fire and with no unreasonable burdens relatively being placed on folks. That kind of takes us through the whole realm of kind of the written discovery platform. This is our interrogatories, RPDs, requests for admissions, ESI that sits under it. What are you going to do with all of this paper once you get it? I say paper, it's all electronic now, but thinking through all of the evidentiary issues that you are facing when you are successful in gathering this information, what the evidentiary rules you need to be aware of, some of the cool exceptions that may exist that allow you get into evidence some of the more interesting issues, and I've purposefully left out the other part of discovery, which is depositions. We'll cover that at a separate portion later today. I hope that was helpful. Thanks for sticking with us through the morning. Some of what we covered is not the most scintillating, particularly written discovery, but thanks for sticking with us. We've covered a lot. Now we're going to take a break for lunch, and then we'll catch up with you shortly.